What would happen to your family and financial affairs if you suddenly became incapacitated? If you don't know the answer, you could be subjecting your family to the unnecessary heartache, complications, and expense of a guardianship. My law partner, Mike Solomon, is here to explain.
Hello, Lori.
So, before we discuss why we want to avoid a guardianship, exactly what does a guardianship mean?
Okay, let me use an example. Let's say you have a gentleman, Mr. Green. He's 67 years old, a widower, excuse me. He suffers a stroke. He's physically unable to handle his affairs, and his mental capacity maybe has been diminished. And he's done nothing during his life to protect, to do any planning. And his assets are all in his name. So his son, maybe even out of town, comes into town, tries to help out, takes him to the doctors, and maybe looks for a nursing home to help him when he recovers. And he'll find out very soon that he can't talk to the doctors. Doctors can't talk to him for privacy reasons. So he can't find out what's going on. And then when he goes to a facility to try to arrange a place for his father to go, he'll find out the facility is a little reluctant to talk to him. Bills are coming in all the time. He can't pay the bills because he doesn't have any authority to do that. Money may be coming in, maybe checks. He can't deposit those. So a lot of things happen. So eventually what's going to happen, he's going to have to get a guardianship appointed. It means he's got to go to an attorney, pay for that, file a bunch of paperwork, possibly gather together as much information as possible about what his dad has, and he may have no knowledge of that at all. So it's a lot of work to do all that together to get to be appointed the guardian.
And then, not only that, you got to account to the court for everything and ask their permission for everything. It sounds like an overall a terrible nightmare. So what do we do to avoid all that?
It's real easy. There are three basic documents, and we've talked about it on the show before: a financial power of attorney, healthcare power, and a living will. Financial power of attorney, you can write checks, pay bills, handle your parents' IRAs or whatever investments they may have. Healthcare power, you can talk to the doctor, you can make the medical decisions, and a living will, of course, is more of an end-of-life instruction. That
allows you to just kind of step in and not have to go to court and go through the nightmares.
You don't have to have all those legal fees, don't have to do all the every 2-year filings to the probate court.
All right. As you can see, a great deal of time, frustration, and money can be saved by your family if you simply have these few simple estate planning documents in place. So take a moment now to think about the question we asked at the beginning of our discussion. See if you know the answer. If not, it's time you take some steps to protect yourself and your family. For more information, look for the Aging Answers supplement to Northeast Ohio Parent Magazine, available everywhere for free. Or for help, call Mike. The number's next.
Call Solomon, Steiner and Peck at 1-888-236-5173 for more information or to schedule a speaker for your organization. Or log on to www.ssnplaw.com.
And thanks for joining us today, and join us again next week. But until then, please remember to make the most of your golden opportunities.
If you'd like to join our kitchen conversation, visit our website, www.goldenopportunities.tv. Like us on Facebook. Call us at 440-742-GO-TV or email us at kitchen@goldenopportunities.tv. We'd love to hear from you.